Once the Supreme Court had upheld the death penalty in 1976 in the three cases, Gregg versus Georgia, Proffitt versus Florida, and Jurg versus Texas, there were still a number of issues remaining for the court to decide. One of those was the proportionality. What crimes did the death penalty apply to? What about the role of the offender in the crime, the role that a person played where several people were involved? For certain crimes, all of the three cases handled or decided by the court in 1976 were murder cases. But what about the death penalty for cases in which the victim is not killed? Many of the states which adopted new death penalty statutes, particularly Georgia, provided for the death penalty not only for murder but for rape, kidnapping, and other offenses. And so the court ultimately decided that. And then finally, for certain offenders, particularly people who are mentally disabled and children, is the death penalty excessive or disproportionate for those individuals? And what we're going to see in today's class as we look through this is the court is going to be counting the states. How many states have provided for whatever the court's considering? Is this show that there's a trend, or does it show that there's a consensus among the states? Because again, we're back to what we talked about with the Eighth Amendment. What are the evolving standards of decency that mark the development of the law? And then we'll also see the court look at whether or not, with each of these questions, the purpose of punishment is served, and that's deterrence and retribution. So let's first look at the question of the role of the offender in the crime. Several people are engaged, say, in carrying out a crime. Each person has a different role. One person may be the lookout. One person may be the driver of the getaway car. And perhaps there was no intent when this crime was planned for there to be any injury to anyone or any loss of life. But often unexpected things happen. The police respond and shots ring out and someone is killed. And then we assess the role of each person. They're all going to be guilty, as we'll talk about in a moment, of murder, but the degree of culpability may be different. And so the question is going to be, are they culpable enough to be sentenced to death? And I'd like to talk about two cases where the Supreme Court decided that. Both of these cases involve the felony murder rule, which is a rule that just basically says anyone who commits a felony or is committing a felony in which a murder is committed, that person is guilty of murder, first-degree murder, regardless of whether he or she committed or attempted to commit or intended to commit the murder. In other words, going back to my example, three people are involved. The person who's the lookout is going to be just as guilty of murder as the person who actually fired the trigger that brought about the death. But there's obviously different degrees of culpability between the lookout and the person who actually pulls the trigger. And of course, part of that is going to be based on what the people do. That was, what actions do they take? And part of it is going to be based on the state of mind. This first came to the court in the case of Earl Inman versus Florida. This was the getaway driver in an armed robbery. And the question the court had to decide was, could he be sentenced to death? He had been sentenced to death. And the question was, could he be sentenced to death if his participation in the crime was, as the court said, tangential, and he had no intent to kill or for life to be taken? In the case, the court looks at the different states, and it finds Florida is one of only 8 states that allows the death penalty for a person who participates in a robbery where the other robber is the person who takes the life. They find that of the 739 people who were under death sentence at the time the Inman case was decided, only 41 were people who had not actually taken the life. So again, the court is looking at what do the states provide, and then they're looking at what has been the practice, even in the states that allowed this. Then the court examines retribution and deterrence. And they decide in this case that retribution and deterrence is not served because Inman's participation was so tangential. So the court holds that the death penalty is disproportionate. Very close case. It's a 5-4 decision. Justice White, writing for a majority of the court, and Justice O'Connor, as well as Chief Justice Berger and Justice Powell and Justice Rehnquist dissenting. The court is now going to look at a case with a very different set of facts, and we're going to see Justice White move over to the other side. Ricky Wayne and Raymond Curtis Tyson broke their father out of a prison in Arizona. They had a large amount of weapons in an ice chest, which they snuck into the prison, and they actually succeeded in this breakout. Their father, Gary Tyson, and another prisoner, Randy Greenwald, were broken out of prison, and while they're trying to make their getaway, they end up breaking down on the road, a couple stops to give help, and it was just a terrible crime. Greenwald and Gary Tyson, the father, kill this couple who've been so nice to stop and offer them a ride, as well as their children. So it's a horrendous crime, but the police apprehend them after a shootout, but Gary Tyson has died. He goes out into the desert. He can't find his way back. He dies of exposure. So the brothers are the people left to be tried. Greenwald gets the death penalty. There's no question about his involvement. But the two brothers are arguing that they did not intend to kill anyone, that father and the other fellow had taken these people away, and that they were walking back to the car at the time the shots rang out and they found out that these people had been killed. And they said also they didn't cause the death of the victims in this case, and as a result of that, their argument was that while they were guilty of murder, they can't be subjected to the death penalty. They can be put in prison for the rest of their life, but not the death penalty. This time, the court looks at the breakout, looks at the guns involved, looks at all of the factors in the case, and decides 5-4 that the death penalty can be imposed against the Tyson brothers. Justice O'Connor writes for the court, joined by the Chief Justice as well as Justice White, who had written the previous opinion in Inman, Powell, and Scalia. And the court finds that there is a consensus among the states that major participation, remember that Earl Inman's participation was tangential. Now the court's talking about major participation, breaking someone out of prison, trying to escape with them, and a mental state that the court calls reckless disregard for human life. That if you participate in an activity like this, you're likely to realize the risk that there may be human life taken as a part of it. And therefore, the level of culpability is more than Inman's, and that's sufficient for the death penalty. Justice Brennan, joined by 3 other members of the court dissent, they would treat the Tysons just like Inman, and they would say that because of the role that they played, because they weren't the actual killers, and because they didn't intend to kill, because they were surprised by what their father and the other person did, that they should not be subject to the death penalty. But the court has now established that major participation, reckless disregard, is going to be enough to make someone eligible for the death penalty in co-defendant cases. The court next turns to the question of whether crimes that don't involve a homicide are subject to the death penalty. Very soon after the 1976 cases, the court looks at Coker versus Georgia, and the question presented there to the Supreme Court is whether the sentence of death for the rape of an adult woman violates the 8th Amendment's cruel and unusual punishment clause. It's important to note adult woman, because even after the court decided this case, there remained a question about whether or not sexual abuse or rape of a child might be eligible for the death penalty. But Georgia's problem in arguing for the death penalty for the crime of rape was that it was fairly well isolated. After the Furman decision had come down and as a number of states adopted new death penalty statutes, only 3, Georgia, North Carolina, and Louisiana, provided the death penalty for the crime of rape. But the North Carolina and Louisiana statutes were both found to be unconstitutional in 1976, in Woodson versus North Carolina and Roberts versus Louisiana. So Georgia now is left as the only state that makes this provision. So when the court now does its examination of how many states have this punishment, Georgia finds itself all alone. The court looks at the last 50 years and notices that a majority of the states have not punished rape with the death penalty in the last 50 years. In 1925, 18 states provided for the death penalty, and as well as the District of Columbia and the federal government. By 1971, that number had gone down just a bit, 16 states and the federal government. But by the time Coker's decided, in 1977, only Georgia. So Georgia is one out of 50 states that provides this punishment. The court then looks to what have the juries in Georgia been doing with regard to this, and it finds that of the 63 rape cases that have happened or that have been tried capitally in Georgia since this statute was adopted, only 6 times have juries imposed the death penalty. So the court concludes that it's infrequent, that is, only one state has it, and even in the state that has it, it's infrequently used. Justice White writes the opinion and expresses not only does the counting of the states, but expresses the abiding conviction that the death penalty is excessive for the crime of rape, particularly since some people who actually kill people don't get the death penalty. What we're seeing here is the court is roughly going to say that the death penalty is limited to cases in where life is taken. The same day that Coker was decided, the Supreme Court just issued a little one-paragraph opinion in a case called Eberhardt versus Georgia, in which it said that the death penalty could not be imposed for the crime of kidnapping, where there had not been a loss of life. And as we'll see, the court is going to decide in Kennedy versus Louisiana that even in the case of a child, the death penalty cannot be imposed where there is no loss of life. Brennan and Marshall in this case say that the death penalty is always unconstitutional, so they join the majority of Justice White writes, and they side with him, but for a different reason. Justice Powell says the death penalty may be constitutional for aggravated rape, and then Chief Justice Berger, joined by Justice Rehnquist, says that rape is not disproportionate, and he looks at Coker in particular. In 3 years, Coker had raped 3 people, he had killed 1, he had tried to kill another, and he had escaped. If ever there's a person, Chief Justice Berger is saying, for whom the death penalty is appropriate for this crime, it's Coker. He describes him as the Chief Justice describes Coker as a chronic rapist and a continuing threat to society. But that's the dissenting opinion. So the result of the case is that the death penalty cannot be imposed in a rape case where there's no loss of life. Now we move to Kennedy versus Louisiana, in which the court took on the sort of exception here. Coker had been about an adult person. Kennedy versus Louisiana presents the question of a child. Once again, this is Justice Anthony Kennedy is going to write the opinion for the Supreme Court. Very interesting what he says in prefacing his analysis of the issue here. That when the law punishes by death, it risks its own sudden descent into brutality, transgressing the constitutional commitment to decency and restraint. He says, the evolving standards of decency counsel us to be most hesitant before interpreting the Eighth Amendment in a way that's going to extend the death penalty. The court is limited in many ways, and now Justice Kennedy is saying we should be very hesitant to extend the death penalty. Decency, in its essence, presumes respect for the individual and thus moderation and restraint in the application of capital punishment. It's a remarkable statement for a majority of the Supreme Court. He's writing for a majority of the court in this opinion, which shows some hesitancy certainly to extend the death penalty and some concern that whenever the court is dealing with the death penalty, it, as he says, risks its own sudden descent into brutality. When we look at some of the other death penalty cases decided by the court, we don't quite see that same concern. Well, the court does, once again, it looks at the states and it finds that 44 states have not made such a crime punishable by death. Since 1964, which is even back before Furman, 8 years before Furman, only Louisiana has sentenced anyone to death for this offense. No one has been executed for a non-homicide crime since 1963. And only 2 people, both in Louisiana, were under the death sentence at the time for the rape of a child. So the court sees here that with regard, again, to looking, is there a consensus in the country with regard to this punishment, death, this extraordinary punishment, this irrevocable punishment, for even a terrible crime? There's no question the crime in this case, in any case involving a child and a sexual abuse of a child, is a horrible crime, but does it is the culpability of the offender such that death can be imposed? And the court here says we're not going to have the death penalty where there's not a loss of life. It points out that retribution, the difference between a particularly depraved murder where the person's killed and where the person is not killed, is a distinction that has to be made here. That deterrence, actually, this may cut against deterrence because Justice Kennedy sees a risk of non-reporting. Of course, the court was informed by a number of briefs, some of them from advocates for children, who point out that most of the sexual assaults that take place are not by strangers who break into the child's bedroom in the middle of the night, but by family members, by teachers, coaches, priests, ministers, people that the family knows, and that if you know that that person who's been abusing you might be subject to the death penalty, it might be a reason for some children to not report the crimes. This is not going to serve the purpose. And also, this gives the perpetrator a motive if the perpetrator is going to be subject to the death penalty to kill the victim. Finally, he adds this point, special risk of wrongful execution, that children, because they're highly susceptible to suggestive questioning, are they're going to be, at least sometimes, not that they're likely to give evidence that's not going to be accurate, but that there's a risk of this happening. And this is what the court is concerned about in all of these cases. Are we worried about a risk of the death penalty being imposed in a case where it shouldn't be, and particularly here in a case where 44 other states have decided not to have the death penalty for this crime, and only 2 people have been sentenced. So the court puts all that together and comes to the conclusion that the death penalty is not appropriate in this case.